session for those who weren't able to make it, and we'll be sending it out. I just wanted to welcome everybody to today's event. My name is Brett Godwin, and I'm the Chief Operating Officer for Sterling Seacrest Partners. We're a privately held insurance agency with about 200 employees in the Southeast. We provide risk management advice to our customers in commercial insurance, employee benefits, and personal lines. Our firm has spent about 60 to 90 days learning to navigate this new world, as well as advise and help our customers to do the same. So we're pleased to be part of today's event. We're going to host a panel discussion primarily on returning to the workplace as the world begins to shift from working from home, or quite frankly being closed, to returning to our places of work. In today's discussion, we're going to take on a wide variety of issues on this topic in hopes to help everyone navigate returning to the workplace safely. In addition, we're going to hit on some coverage issues which continue to rapidly evolve. As you have questions, we'd love for you guys to use the chat function. We're going to leave 10 to 15 minutes at the end to answer additional questions. I'm pleased today to be joined by our three distinguished guests. We have Christopher, and you'll hear me refer to him as Smitty Smith, if you want to wave to everybody, is a partner at HunterMaclean and the team leader of the logistics practice group. Smith has a wide range of experience in business law and focuses his practice on logistics, litigation, insurance coverage, construction law, contract drafting, and bankruptcy and creditors' rights. He represents businesses and individuals in matters ranging from physician recruiting agreements, covenants, to non-competes. From breach of contract to chemical plant explosions, he has litigated complex cases from Georgia to California. Smitty is also a mediator with Miles Mediation in the Savannah office.
Good morning, everyone.
Go ahead, Smitty. Say
good morning, everybody.
Sarah Lamar is a partner also at HunterMaclean and practices in the area of employment law. So she's been very busy. Sarah has experience representing employers in employment litigation in state and federal courts regarding discrimination in employment laws such as Title VII, the Age Discrimination in Employment Act, Americans with Disability Act, Family and Medical Leave Act, and the Fair Labor Standards Act, among others. She also represents employers in breach of contract actions, including non-competes and tort claims, and in agency investigations brought by the U.S. and Georgia Department of Labor, EEOC. She conducts in-house training for employers and advises clients on a variety of human resource issues, including their federal affirmative action and immigration law obligations. Sarah, say hi and wave to everybody.
Hello, everyone.
And Suzanne Kirk is a president and executive HR consultant with Employee Development Strategies, Inc., a human resources and organizational development consulting firm established in 2011. Suzanne works with clients to ensure their HR practices embody their organization's culture, business objectives by aligning performance management processes to business strategy. In addition to crafting custom HR foundation tools and processes, Suzanne is a dynamic facilitator of board retreats, strategic sessions, and custom learning programs for all audiences, helping focus on the people side of business. So Suzanne, please go ahead and say hi.
Hi,
awesome.
Good morning, everyone.
Awesome. So again, if you guys have questions as we go along, please use the chat function because we would certainly love to take those. So let's get this party started. Sarah, let's start with you. What is an employer's actual duty to provide a safe workplace?
Well, Brett, generally OSHA has a general duty clause that all employers must furnish each worker an employment which is free from recognized hazards that cause or likely to cause death or serious physical harm. So every employer out there is subject to that general duty clause. Over the years, with various epidemics or pandemics, OSHA has determined whether they are recognized hazards. And back when SARS was a big issue, when West Nile virus and bird flu were big issues, they were considered by OSHA to be recognized hazards. I think that OSHA is certainly heading in the same direction with COVID. Just last week, it required that all employers, not just healthcare providers or employers in certain industries, start recording COVID-19 work-related illnesses or deaths as OSHA 300 on their logs. So Certainly, OSHA is looking closely at what employers are doing with respect to COVID. And I'll just briefly add there that it has issued guidance on its website for months now about COVID, really pretty straightforward and easy to follow. It goes from very high risk workplaces to low risk workplaces and what all employers from the office setting to the manufacturing floor need to look at. In addition to OSHA, of course, there's the CDC guidance, which I'm sure we'll talk about a little bit more later.
Thanks, Sarah. And so, Suzanne, can you expand then on how we as employers can ease the return to work process for our employees?
Sure. So a lot of what Sarah described is much of the what we have to do as employers. And I think we would be remiss if we didn't also discuss the how we do some of those things, right? And so if you think about every employer, employee, and all of us as humans, we have experienced this pandemic in very different ways. And everyone will bring their own fears and anxieties and realities back to the workplace. You know, early on in this process, I was participating in a Great Place to Work webinar, and there was a phrase from that stuck with me, and it was humanity first, business second. And acknowledging as we bring people back that they will bring those concerns, those fears, their anxieties back to work. And I think if we can proactively acknowledge what some of their concerns might be, and all of the things that we as employers are doing to make the workplace as safe as possible for them, the OSHA guidelines that Sarah referenced, it might be about staggering our schedules as we bring people back so that you don't have the entire workforce trying to access an elevator at the same time, for example. It might be considering how we bring people back into the workplace and maintain a safe environment. Think about all of the shared pieces of equipment that we have, from the copier to the coffee machine, and how are we ensuring that they are sanitized and maintained in a very OSHA compliant manner as we bring people back. But part of the process too is just really collaborative problem solving as we bring people back. Nobody has all of the answers right now. And I think we need to acknowledge that we are building the plane as we're flying it, so to speak. And so as we bring people back, focusing on communication, involving our people in our problem solving, and acknowledging some of the concerns and fears they're bringing back into the workplace is really critical to help bring them back and help them be productive as much as possible while maintaining that humanity focus to our workforce.
Thanks, Suzanne. So there's a great scale out there that we use on the internet where one being people who are afraid to leave their house, and then there's the fives who want to come up and give you a hug. And you know, with 200 employees, we've got some ones, some twos, some threes, some fours, and some fives. And so creating a workplace environment where all those people can coexist, right? That's been an interesting challenge.
Absolutely. And part of that, Brett, is, as we see, we've got lots of opinions about what everybody thinks we should and should not be doing. And we need to be prepared to navigate that by establishing as much as we can the rules of the road, so to speak, as people come back in, so we can already have, hey, these are our defined guidelines that we've decided keep our workplace the safest for you all. So welcome back. And here's how we're keeping you safe by setting some of those rules out the gate.
So back to Sarah, if we could. So Sarah, as Georgia reopens for business, how are businesses to navigate situations where employees refuse to return to work? And what
Yeah, that is just a huge issue. And again, you have a spectrum between employees who genuinely have, for instance, medical issues or live with someone with serious medical issues, and for good reason do not want to return for fear of health, to, unfortunately, the other end of the spectrum, which is employees who don't want to come back because life is good on unemployment comp. And that is a real issue of employees rejecting job offers because the federal booster payment of $600 a week is too good, plus the regular unemployment. So the federal government, U.S. Department of Labor, has come out pretty strongly and said, we do not tolerate fraud in unemployment claims. So if you are not coming back to work for no good reason, then you are not going to, in theory, get unemployment, and the employer should stop filing partial claims on that employee's behalf. Now, there's a wrinkle in everything, because if an employee argues at the unemployment comp stage that I did in fact have a good reason for not coming back because I have a health condition, for instance, that makes me vulnerable to COVID, then that person still may get their unemployment. But the employer will have to argue against that and perhaps appeal, depending on the facts of each case.
And so, Sarah, we had a follow-up chat question, which is related, and you know, this may be difficult, but there's some nuance. So, how about employees that are just afraid to come back? They're currently working remote, and they're just afraid to come back. Any comments on that?
Yes, mere fear of returning to work is not a good reason not to return to work, as far as the unemployment compensation system is concerned, or frankly, any other major law that we worry about in the employment space. That said, if the employer can work with that employee and try to understand what are the fears and can they overcome them with reassurance of safety protocols, hygiene protocols that Suzanne was referring to, and reassure them that the workplace is as safe as it can be, which of course is not perfect. That would be the optimal way to try to work with folks to allay their concerns.
So just one last follow-up then. So what obligations do employers have under Families First if an employee cannot return to work?
Right. So Brett raises the FFCRA, Families First Coronavirus Response Act. That's a mouthful. But essentially, if you are calling an employee back to work and the employee raises one of the 6 reasons under the FFCRA for requesting leave, which would include, for instance, your doctor has told you to stay at home because of a fragile medical condition, or you of course have COVID, or you're caring for someone with COVID, or you have kids that are at home and you have no daycare for them, then if that person raises as a reason why they can't come back to work one of those qualifying reasons, then the employer should be offering them the FFCRA leave if that employee is otherwise qualified for it. And just as a reminder for folks, the FFCRA covers employers with under 500 workers, and for the childcare provisions, the employee has to be just employed for 30 days before the leave is required to be eligible.
And if I can jump in there, Brett, I'm hearing a lot of questions about this from employers. I think we're seeing, as we start to bring employees back to the physical workplace, the request for these types of new leave is on the rise. And I think a lot of employers thought, oh, phew, we didn't have to navigate that. But now employers, as they're bringing their people back, are starting to have a workforce that is becoming aware of this benefit that they may not have realized was out there previously. You know, like any of our workplace notifications, when FFCRA was released, it was released with a here's the mandatory notice that you have to place in your workplace. Well, in most cases, the workers weren't there to see it. So depending on how the employer distributed it, if they did distribute it, some employees are just becoming aware of the benefit and realizing, oh, wait a minute, I meet one of those 6 qualifying criteria. So I think employers should really prepare to start seeing more requests for information regarding how they navigate leave. And so having someone within the organization that is knowledgeable enough to help guide people in that process, same person that would help them navigate FMLA if it's an organization of the size that qualifies for that, it's coming, I believe.
And Brett, I would just add to what Suzanne said, The Americans with Disabilities Act should not be ignored during this process. So if an employee says, I can't come to work because of whatever medical condition, even if the FFCRA doesn't apply, the employer may be required to offer reasonable accommodation to that employee under the ADA, which could potentially include working from home if that was possible, for instance.
Great. Thank you, guys. That was excellent. So I'm going to shift gears a little bit. And Smitty, I'm going to come to you. Can you tell us that all of our business losses due to coronavirus are covered by insurance, right? Are you willing to step out on that limb for us?
I am not, Brett, but thanks for asking. There's some coverage out there, but it's going to be an uphill battle. A question I get from my clients all the time is, we've lost a lot of business income during this shutdown, during the coronavirus, and I'll continue to lose it during the reopening. What can I do about it? What about my business income, business interruption insurance? Now, most commercial property insurance policies provide coverage under an endorsement to the insured's property policy. A typical clause, I'll read here from the standard ISO form, provides, we will pay for the actual loss of business income you sustain due to the necessary suspension of your operations during the period of restoration. The suspension must be caused by direct physical loss or damage to your property. Now, the key terms in this are actual loss. The business income will cover the loss sustained as a result of this loss to your property. The business income is your net income, net profit or loss before income taxes that you would have earned or could have earned, but for the event, along with your continuing normal operating expenses. The period of restoration is another interesting term, but that's the time between the event and repairing your property and getting it back up and running. But of course, not all business interruption claims are a result of damage to your property. Some are a result of damage to a supplier. This would fall under a less common form of coverage you might have called contingent business interruption coverage. This provides lost earnings when a third-party supplier or manufacturer shuts down and they directly impact your goods and services. A good example of this is the Japanese earthquake and tsunami that back in 2011 that left a bunch of American manufacturers basically shut down as their supply chains collapsed overnight. Another type of business interruption coverage you might have is leader or attraction coverage. This is when there's damage to property nearby that attracts customers to your business. A good example of this one would have been the 2010 Horizon Deepwater oil spill and all its impacts on the Gulf beaches and hotels and fishing industries. And during this COVID-19, we all know Disney World shut down and a number of businesses may look to this, maybe Tybee Island Beach, maybe the Savannah Squares. Those are areas to be explored under that type of coverage. And lastly, there's civil authority coverage. This has become a recently very much debated topic. That is when the insured is unable to access your property due to a government order as a result of physical damage to nearby property, not your property, but something nearby. But it is important, without physical damage of some kind, there will not be coverage. We've all been through this. A number of business owners listening in will have had claims during the hurricane evacuations. These will be arguments used based on the government's shelter-in-place orders that we're all under. But one thing you got to keep in mind is that following September 11th and Hurricane Sandy, many insurers tightened up the policy language to really ensure that property damage was in fact a requirement for any coverage. But with this coverage in place, there are two real main obstacles to getting coverage that every insured will have to look at. The first is the requirement of direct damage or loss to the property at a covered premises. And second will be the bacteria and virus exclusions contained in many recently issued policies. The key event that triggers business interruption coverage is going to be the property damage. Without property damage, there's not going to be any coverage. Under the ISO form, it must be caused by loss or damage to property at your premises. For civil authority, it must be due to direct physical loss or damage to property other than your premises. Therefore, the threshold question is going to be whether the presence of the virus itself constitutes property damage. Now, we all may agree that the coronavirus doesn't constitute permanent damage to property, but from what we understand, it can be transmitted from surfaces, touching the infected surfaces. So the virus could be present on restaurant tables or airline armrests and other surfaces that arguably damage the property. You know, Brett, if I came into your office with the coronavirus and I coughed all over your desk, I'm pretty sure you'd say this has been damaged and I'm going to need another desk right now. But, you know, as a lawyer, we're looking for guidance from the courts. And the courts have not specifically decided whether this virus can constitute property damage for coverage. However, they have looked at whether the presence of harmful substances at a property can be property damage. And a case out of nowhere in New Jersey that has gotten all kinds of attention is the Gregory packing case. In that case, the District Court of New Jersey found that the release of ammonia that occurred in a facility actually constituted property damage. The court held that property can sustain physical damage without experiencing structural alteration. Along the same reasoning, a court in Oregon, Shakespeare case, had to cancel theater performances due to smoke blowing in from wildfires. The court there reasoned that the damage didn't have to be structural or physical to be physical as long as it rendered the property unusable for its intended purpose. And you know, some other cases have followed suit that you can use as an analogy. There's a Western Fire case in Colorado with gasoline vapors. There is the Seco case in Massachusetts that has carbon monoxide levels that rendered the building uninhabitable and therefore were a direct physical loss. So under the reasoning in these cases, you could argue that the presence of coronavirus has physically damaged the property, such as at a restaurant, by rendering it unusable for its intended purpose.
So the courts will certainly have this settled by next week then, is what you're saying.
Well, you know, we're not looking at having any jury trials in the near future, and that's a whole nother discussion that I can go on and on about. But, you know, one thing, the first thing a number of policyholders are going to have to look at is their actual policy. While the coronavirus is all around, a lot of this will be governed by your actual individual policy language. And as a result of the SARS outbreak a few years ago, a lot of policies contain a virus and bacterium exclusion that states, reading from the ISO form, we will not pay for loss or damage caused by or resulting from any virus, bacterium, or other microorganism that induces or is capable of inducing physical distress, illness, or disease. So that is going to be a huge hurdle. And lastly, you know, one of the issues that will arise is how long do you need for that period of restoration? How long is the surface contaminated? An insurance company may take the position that you just need a day of heavy deep cleaning and antimicrobial agents and try to clean up your restaurant. But then the owner could counter that, well, the restaurant got contaminated again with each restaurant customer that comes in. So that even the period of restoration is going to be argued about. And then, was your business closed because of the coronavirus, or was it just closed for a safety precaution rather than a result of virus containment and damage? But I think the argument most people are going to make is hinges on that civil authority coverage I mentioned earlier. And remember that under the civil authority coverage, direct physical damage to your property is not required. It can be property or damage to property other than yours. And there's a recently filed California case with a restaurant, French Laundry. They're arguing that the infected public spaces has closed them down. You can look at like Mayor Bottoms in Atlanta. I think she put in her order that there was an extreme likelihood of destruction of property. So everyone will be looking at the civil authority exception. But bear in mind that if that triggers, that you'll still, coverage starts 72 hours after the order in most policies and ends 3 or 4 weeks later. So you do have to check your policy.
Thanks, Smitty. I want to pivot to Sarah and a very related topic, right? So, Sarah, can COVID-19 be considered a work-related illness covered by work comp insurance?
Well, Brett, we talked a few minutes ago about OSHA's view of COVID. And so looking at the state workers' comp laws is another very interesting aspect of this crisis that we're in. Most of us on this webinar understand that workers' compensation is an exclusive remedy for work-related injuries. Workers' comp also covers work-related illnesses, although that is, the illness side is much less litigated and claimed than the physical injury side of things. So Georgia has a pretty high bar for an employee claiming an occupational illness, and I won't get into all the criteria, but Georgia also has a very strict exclusive remedy clause, which means that almost all of the time, an injury or illness that occurs in the workplace is going to be subject to workers' comp laws, and that is all that employee is going to get. There are some exceptions to that for intentional conduct that is not work-related, for criminal conduct, for instance, and we may see some arguments here in Georgia, although I'm not aware of any yet, that an employer's conduct was intentional, not related to work, or was criminal in its failure to follow basic safety measures. But again, the last time I checked, there were no claims of that type filed yet in Georgia. There have been in other states, though.
And Sarah, if I'm not mistaken, right, it varies pretty greatly by state, right? So you really have to pay attention to the variety of
Yeah, and in fact, the first case that was filed related to a COVID death against an employer is in Illinois against Walmart, where 2 employees passed away from COVID that their families in the suit allege occurred because of Walmart's failure to follow basic CDC OSHA guidance and failed to warn employees that others had COVID in the workplace and do anything about it. And so in Illinois, those plaintiffs are trying to overcome the workers' comp exclusive bar doctrine, and Illinois has different laws, so it might work in Illinois.
Excellent, thank you. So Smitty, back to you then. Can you sort of give us some big picture takeaways in regards to the litigation, whether work comp, BI, and how businesses can protect themselves?
Yeah, well, right now, everyone needs to know that the court system is not, civil cases are not a priority right now. We've been told that, to expect jury trials some point in the distant future. And when we do get them, obviously the criminal cases will come first, and those will need to be tended to. When can we see a jury again and have 12 people sitting next to each other, or have 40 people out in voir dire so I can ask questions? And then where do they deliberate? That is going to be an issue the courts are very sensitive to in getting back underway. But there's going to be litigation over these policies as, businesses are fighting for their lives. And behind the scenes, you read the articles on different politicians are trying to angle for coverage, and our insurance commissioner does different things. I think his 60-day suspension is coming up. But some states, in a result of past disasters, have looked at mediating, setting up large-scale mediation programs to try to address a number of claims and try to free up the burden on the court system. And some type of alternative dispute resolution may be crucial in this juncture, as we don't have a functioning civil system at this moment.
Excellent, thank you. So Suzanne, I want to get back to you if we could, and let's pivot again a little bit and discuss the fact that many employees are still working from home, right? And in regards to that remote workplace environment, can you touch on productivity, culture, that's a big one, right? And maintaining a positive work environment.
Sure. So a recent SHRM study, and SHRM is the Society for Human Resource Management, said that 64% of salaried US employees have been working from home through this pandemic. And that's a tremendous jump from what the numbers were previously, which was about 32% on some regular basis working from home. So we did it because we had to in many cases, right? So it was mandatory and we figured it out. It doesn't necessarily mean that it has to endure as something that is the norm going forward. You know, working from home, there's pros and cons and data that will make the argument on both sides of the coin about whether it increases productivity or it diminishes the culture. And you can find data to support your argument no matter where you fall in your opinion on that. But as we navigate this process and people have been working from home, I'm hearing a lot of questions to employers of, well, hey, it worked. Can't I continue to work from home? So in a perfect world, an organization would have a policy within their employee handbook that already addresses their work from home procedures. And for many, it is somewhat of a benefit to earn in that you have to have been employed with the organization for a 12-month period before you're allowed to work from home. And there are a lot of considerations to establish a productive work from home environment. And in that policy, if you don't have one, now might be a time to examine how you want this to work, because it's not for every position, obviously, and it's not for every person. And so as you look at some of the conditions and criteria, if you choose to enable people to continue to work from home, what are the expectations, right? So if you mentioned the impact on productivity, well, what are those productivity expectations? What are the deliverables? Is it very clear what each employee working from home is supposed to be accomplishing on an ongoing basis? And then thinking about what those expectations are for responsiveness and being available. If we send someone a text at 8:30 p.m., do we expect them to respond? What are the guidelines for that? Are they an exempt employee? Are they an hourly employee? Or that's time that's worked on the clock and should therefore be compensated? So just establishing some of those rules and expectations about when they should be available, how they're available. There's a lot of technology considerations that people had to figure out because they had to figure them out along the way. But the security of data, for example, is a huge one. And are we confident that going forward, it's an amenable solution to protecting the integrity of client data, organizational data based on what the job is? But consider the cultural implications, right? So you mentioned that. So we really miss when we're working from home, the good morning in the hallway and the greetings around the coffee machine or the water cooler speak. And you miss that when you're working from home. And so if we decide as an organization that working from home is a suitable environment that's conducive to performing certain types of work, and we establish what some of those expectations and criteria are, what are the things that you can continue, some of the things that maybe you did throughout this process while people were working from home to engage your workforce? You know, I've worked with a lot of companies that have done some fun, you know, happy hour, trivia, Zoom meetings, and that kind of thing. And I think those are important. And as one that manages others, managers have to look for those ways to keep engaged those people that are working from home. We also need to help our employees balance that time. When we're working from home, it's very difficult to not have that physical transition from our workspace to our home and living space. And so making sure that we're helping people set those boundaries. You know, one of the pieces of advice I give folks is don't work where you relax. If you're taking your laptop to the couch where you're watching Netflix, it's really difficult to then make that your relaxed space if it's become your workspace. And so how can you have a dedicated space somewhere in your home? Not all of us have, you know, the luxury of having a separate room just waiting to be our office. And so we're doing what we can do, whether it be the dining room or a closet where somebody's working out of, but making sure it's a separate space, setting clear expectations of availability and deliverables, and working for ways to keep engagement throughout the process with your people, knowing that they may become isolated. You know, so many of us, as we work from home, we've been navigating all sorts of other challenges, whether it be a spouse or a partner that's working from home or has lost their job and we are in financial crisis, or we've had children at home and now next thing you know, I'm teaching 8th grade algebra very poorly while I'm trying to work. I came across a sentiment early on in the process that I thought was really important to consider, that it was, we are not working from home. We are navigating a global pandemic while trying to work. And I think that really puts some needed perspective on the expectations we have of our people and how they work, and creating that balance for the human aspect of our employees and helping them be set up for success if they continue to work from home. But I'd say if you don't have a policy, it might be a great time to collaboratively develop one with your people as to, hey, how do we want this to work? Who's it for? Who's it not for? And what are the criteria?
And Brett, I would just like to add that in this time as we hit summer, employers are going to have to be flexible. I mean, you have people who want to work, who are your top producers. But as of last week, my kids just finished school. You know, I've got twins at home who are probably smashing something as we speak. My wife works as well. So every working parent is going to have to balance, how do we come back? There is no school. We found out most of our summer camps and other activities have been canceled. So even in cases where you got people raring to go back to work, everyone's going to have to balance childcare in that process.
That's a really good point, Smitty, because, and a question came through on the chat about this, about the FFCRA, the language, one of those 6 conditions, and Sarah, chime in on this, one of those 6 conditions was that my place of education for my child or childcare is not available. And so for many, I'm seeing this is applied to summer camps, is it not, Sarah? So if your summer camp, your plans for childcare in the summer are not available, you qualify for that portion of FFCRA.
It's the summer camps. It's even your babysitter is not available. Your daycare provider, not just a facility, but potentially, you know, a human you are relying on. And the FFCRA expressly says that if someone can't work from home full time because of having to take care of kids, that intermittent leave is possible, but also if they can't work at all because of kids, they have up to 12 weeks of partially paid leave under the FFCRA.
There's a follow-up question I just saw on the chat too, just to clarify. So unlike FMLA, in which you have to have been employed for 12 months and worked a certain number of hours, the FFCRA just requires you to be employed for 30 days. But in this case, the question from one of the participants is that if they have not been working for 60 days in this case, does that impact FFCRA? My understanding is they were an employee for more than 30 days. You have any insight on that, Sarah?
Yeah. I agree. It would perhaps defeat the purpose of the FFCRA if, because you weren't working because of COVID, that you weren't qualified for the leave. So I would agree with that interpretation.
Yeah, no, it's a really great discussion. I mean, for what it's worth, it's Sterling Seacrest, right? So we were voluntary return to work in May, and we're going to begin to very gradually phase folks back in June. But we've been very careful to survey everybody and be as empathetic as possible, because Smitty touched on it with the camps being closed and all that. And so, we've landed on that balance and being empathetic and flexible. So really good discussion. Did want to pivot a little bit back here, Sarah, to you, and sort of how would you suggest we address technology, BYOD, wage, hour pay, and privacy issues in regards to remote work environments?
Well, Brett, Suzanne touched on a bunch of these issues, and each one of them has a legal component. So in terms of technology, it's really important if you're having folks work from home that they have secure devices that they're working on, and that the company's technology, trade secrets, confidential information, et cetera, is not being compromised on the employees' machines or by family members who use that same computer for discussions that are business sensitive, confidential discussions. You're probably not in the best place to have those in the middle of your kitchen with everybody else at home with you. So having some policies, internet, electronic technology policies, and revisiting those for the situation that we're in now, which they probably were not envisioning when HR and the company put those policies together. And that leads to the BYOD, bring your own device policy, which often is a separate policy in an employee handbook that addresses an employee's use of a personal device, be it tablet, phone, computer, on company business, and making sure that the IT department knows and has access to wipe data if that person quits or loses their device, or et cetera. So those are two policies that are important to revisit, especially in this time. And Suzanne also mentioned wage and hour issues. So that statistic about salaried workers working from home, salaried is often used as a proxy for exempt. So these folks are not entitled to overtime. So they can work at all hours and still get paid the same salary. Whereas someone who is hourly or non-exempt, they have to clock their time even when they're working from home. So how do you manage that person's productivity, and how are you going to measure that from the business perspective, but also the employment law perspective, because you don't want to run afoul of the Fair Labor Standards Act during this time. And for instance, as Suzanne noted, require a non-exempt person to answer emails at 11 p.m. Well, that means they're going to have to clock in to review that email and then clock out afterward. And how is that going to be managed? So those are just some of the, privacy, confidentiality, technology, wage and hour issues that arise in working from home.
Great, thank you. So Suzanne, last question here, prepared question, and then we're gonna, we got a lot of great questions on the chat we can get to. So Suzanne, there's been such a disruption. Maybe we do, can you give our attendees some more suggestions on how we can preserve and strengthen during this uncertain time?
Sure. So I think how an organization has navigated this pandemic with their workforce is a great indicator of their corporate culture, good or bad. And we've all heard different versions of stories that have occurred out there, mass layoffs via Zoom, where a whole, department is furloughed without any opportunity for discussion. That's not how we treat people. And so considering our culture going forward, I think the first place would be to find what the things are to celebrate. All of our organizations have been impacted in different ways, and looking for what have been the silver linings in this, right? So I worked with a company recently that they were really celebrating. They had not furloughed any employees. They had not had to reduce hours, and looking for those things to celebrate as we bring people back and focusing on the positive. What is the economic position of the organization? If it is still viable and strong, let's celebrate that. If our workforce is healthy and all able to return to work without any major health disruptions, that's something to celebrate. And then even the little things, as we've worked from home and we've seen glimpses into people's homes and kids running around in the background and pets jumping up on us, we're seeing the more human aspect of our coworkers. And I think there's a real benefit in that when it comes to what our culture is. Another component is, we talked about this at the very beginning about the return to work and the fears and anxieties that some members of the workforce are going to bring, is to really consider the mental health of our workforce and what are we doing to address some of that. If your insurance plan has an EAP component, employee assistance program, are we proactively reminding our employees of the resources available to them? We cannot expect our workforce to come and be productive if they are in some kind of personal crisis, whether it be a financial crisis because a spouse or partner has lost a job. We see that substance abuse is on the rise, that domestic abuse, financial crisis. These are all very real things that members of your workforce are going to be bringing with them when they come back to work. So can we offer EAP resources? Can we post variety of hotlines and helpline resources that are available both in our community? Our United Way 211, for example, is a great resource locally, and there's a lot of resources available in each of our communities. But then we can just look at how are we incorporating aspects of whole health into the workplace? Are we bringing exercise into the workplace? Can we offer exercise programs? Can you offer a reduced membership as part of your health insurance into a fitness center locally? A meditation app. I had one client that they paid for the upgrade of the Calm meditation app for all their employees, and it's little things like that address the humanity side of bringing a workforce back that will impact the culture. And Brett, you had mentioned surveying your people. I'd say lastly, this is a great time to survey your people. Hopefully you're doing something like that annually or at least periodically to take some type of engagement survey pulse of your workforce. And if you've done them in the past, it's a great opportunity to take a mini pulse survey check now, compare it to your most recent results to just say, how are we doing? If you've not done it before, it's okay to implement that now and just ask the same questions. How are we doing? What do you need? What are your concerns? Not that we want to dive into the personal life and mental health side of things as the sole purpose of a survey, but just a real opportunity to engage our team in collaborative discussion, hear where they're at, and make a plan together about how we move forward successfully.
Some of the things we've done that have been really well received. So we've had what we call coffee catch-ups, where virtually you're setting a one-on-one appointment with somebody at 8 or 8:30 in the morning and just chatting, not about work, but just catching up. We've done virtual happy hours. We had a virtual rock, paper, scissors tournament, posting pictures of people working out or what are you cooking for dinner.
Yes.
Again, to create some of that connectivity. We're so probably 25% of our workforce is back in the office. We're still not taking these kind of meetings in a conference room together, right? So yeah, you see somebody passing in the hall, but keeping that connectivity is still really important.
That's huge. I want to play rock, paper, scissors now on Zoom.
I'm still upset I lost in the quarterfinals. Which, by the way, the timing virtually very challenging. But
very challenging, yeah.
So now we got about 15 minutes left. I want to pivot to some of these great questions that we've had here come up. So first one, I think, Sarah or Smitty, this is probably good for you, and it says, should we as business owners be concerned with opening up fast or too fast, RE liability issues, right, for us or our employees? So if you guys can comment on
and
that.
I can tackle that initially. I think you just need a plan in place. The governor's order has, we're back to business in the state of Georgia, and within the guidelines that the governor and the CDC and OSHA have put out, it is very tricky to navigate all of that and still operate at any profit. So I think all of that needs to be taken into consideration as you open up and how fast you decide to open up. But the liability issues are their potential, despite the workers' comp that we talked about as the exclusive remedy. And I think employers do need to be concerned about creating the safe environment in this pandemic. So look at those very seriously before deciding to open up. And that could go to customers too. What kind of environment are you inviting customers back into your businesses, and are you taking the necessary precautions? If you fail to, then there could be exposure. In all of these cases, whether they're customer or employee, the issue of causation and proof is going to be really hard. I got COVID because I touched a shirt that someone with COVID had touched at the same clothing store. That's going to be really tough, but it doesn't mean the claims aren't coming, and it doesn't mean it wouldn't be very expensive for businesses to respond to.
Yeah, I would echo everything Sarah just said, but for liability in a third-party action, let's say you run a winery and have a tasting room and income customers, and someone sues you because they say they got COVID-19 at your winery. That's going to be a tough road to hoe. To prove a cause of negligence, you got to show a duty that was breached. What is that duty if you've got your government mandated safety measures in place? How do you prove proximate cause that your presence in the winery is what gave you the COVID virus? I think that'll be tricky, but on the back end, as Sarah said, it won't stop people from making claims. Issues of proximate cause are normally for a jury. And as I said earlier, I'm not sure we're going to get those again.
Great, thank you. And so this one has come up a couple of times. I think it's a good one. So it's probably Suzanne, you or Sarah here, but what can an employer, in reference to COVID-19, ask employees prior to authorizing a return to work? Can really temperature checks of employees be done or required? I'm thinking about, are we recording those temperatures, and what implications of those are? Can wearing of PPE such as masks be required or mandatory in a workplace? So there's a bunch of stuff in there that maybe you guys can comment on.
I can start on that, Suzanne, and then take it away after me. But yes, an employer can require temperature checks. The EEOC has expressly stated that. You would want to do it across the board and do it in a way that the temperatures that are taken are either not recorded. There's some interesting apps and software out there that enables an employer to do that without recording anything, so you don't have to worry about confidential medical information. But if you're just doing something in a more analog way, then if you're going to record the temperatures, you must keep them confidential, because that's essentially a medical exam under the Americans with Disabilities Act. So you also have concerns about the folks taking the temperatures, and how are you protecting them with PPE, masks, gloves, etc. So those are definitely some concerns, but the EOC has allowed the temperature taking for sure during this pandemic. We might get to a point where it says the pandemic has waned enough, we don't think that's justified, but we're not there yet.
Mm-hmm. Yeah, it's a weird place for HR professionals to be in, because we're so used to really tightly protecting any employee's health information in the workplace. And it's really been a don't go there kind of perspective. And this is new territory. And so I would say, echo everything that Sarah just defined, but as an employer, making sure you're using those CDC guidelines as what those very specific things you can and should check, and what the criteria and the parameters are for those. But to ensure you are doing so consistently with your workforce, you cannot pick and choose who comes through the door and who you're testing and who you're not. And I think being really careful with some of that, and then making sure that what do we do with that data, as Sarah described, is critical, because it may bring to light someone's personal health information that is outside of COVID, but perhaps they're immunocompromised for some other medical reason. And how do we manage that data, such as to preserve the privacy of our employees, is really important.
Where does everyone get a supply of surgical masks or approved masks? I mean, mine right now is made out of a old Georgia Bulldogs t-shirt. So do all the employers out there have these adequate masks to require them, and then say, go get your own, and what is gonna meet that requirement?
Absolutely. I don't think we can just make a mandate without offering how an employee is going to fulfill that requirement in the workplace. It's just like the working from home. We can't mandate you to work from home and expect you to be productive if you don't have a computer to do so in your home.
But all that said, if an employer wanted all its employees to wear masks and in the perfect world supplied everyone with a mask, I think that they could require it. If there was some medical reason under the ADA someone couldn't wear a mask, then that would probably need to be accommodated. But I believe the latest CDC guidance is strongly encouraging masks, not mandating them.
And so you touched on this, Suzanne, but I got the follow-up question here. Can we require temp checks for visitors and vendors who come to the office?
So I'm sure we're all seeing a lot of signs as we enter different places of business about what their requirements are to enter that place of business. And I think as an employer, what I'm seeing is people are posting signs that might be use different entrances for our customers, for our employees, what the requirements are. Please don't enter if you meet any of the below criteria. From a legal perspective, I would certainly turn to Smitty and Sarah regarding from a customer basis. From the employer perspective, you can absolutely, as Sarah just described, mandate some of those precautions. But from a customer perspective, I would defer to our legal experts.
Well, if you're a quote unquote customer at a hospital, which means you may be a patient, I wouldn't have any problem with that. I haven't seen any businesses requiring customers to have temperature checks, but there may be some out there. Smitty, what have you seen in that regard?
I have personal experience with it. My good friend and dentist here in town, I came in and I was told to remain in my car until they came out and gave me a health questionnaire. gave me a mask and took my temperature, and then I was escorted by myself down a hallway to the room, and I never had contact with anyone other than my dentist. So as a person who was desperately in need of dental services, I was more than happy to comply with their requirements. And I understand it's for the safety of all the patients and the dentists and everyone working at the office.
Well, and I know the Savannah Downtown Business Association has really been bringing businesses together to focus on, I believe it's the Savannah Safe compliance optional program for downtown businesses to get on board with consistent protocol. And if you've been downtown Savannah or any highly populated area, such as over the holiday weekend when it was chock full of people, I certainly appreciated seeing businesses that had those criteria posted on the door to the business that requested everybody to please wear a mask to enter, and immediately being offered hand sanitizer when we entered the store. I think some of those things are great protocols for businesses to have in place for their customers. It's for their protection.
Yeah. And Smitty, maybe back to you on this one. So if a customer refuses to follow the business rules, right? So you didn't wait in your car at the dentist, right? Can that business bar that customer from entry without recourse?
I believe they can. I think that they have a right to refuse service following safety guidelines. And if, you know, there is another camp of people out there now that don't want to wear masks and don't want to follow these rules, and they may go on the offensive and, you know, attack you on social media. But I think I'd rather hear from that business that we're sorry you're unhappy with our policies. It is our goal to keep everyone safe during these challenging times, and we look forward to serving you in the future. I think that, you know, up to the business to make those calls based on the guidelines.
Excellent. So probably the last question here, and it is, we've touched all over this, but it's come up a couple of times in the chat. So I do want to sort of readdress it. And so how do you handle, again, the employee who doesn't want to return to the office after the governor order expires? In particular, the follow-up question there was, if you call an employee back to work and they say they'll come back after the shelter in place for those over 60 or compromised immune system, do they stay on unemployment or ask for new federal leave? So maybe retouching on some of that would be great.
Sure, I can touch on that. First of all, I think some documentation is in order for that type of scenario. So if someone says, I can't come back because I live with someone who's medically fragile, or I can't come back because I have some underlying condition, it is perfectly appropriate and I think encouraged for the employer to ask for documentation of that fact. And upon receiving the documentation, that will help dictate what the next steps are. And again, depending on if the employer is subject to the FFCRA, that person who say is on furlough and they say I can't come back because of a protected reason under the FFCRA, they might be placed on leave. Whereas if the person is not, if the company's not subject to FFCRA, or the reason they're giving for not coming back isn't subject to one of the reasons under the FFCRA, then potentially they might stay on unemployment. But that goes back to what I said earlier in this presentation, which was it might be considered a quit, and then they have to prove their own unemployment. Excuse me.
I think you establish conditions of employment, right? And if you have exhausted all of your rights to any of these leave programs that are being offered, then the employer has established their conditions of employment, and opting to not comply with them is therefore potentially a resignation. You know, I think we have to balance the humanity of it with the business side of it. Is, you know, approach it from a human perspective and make sure that they're aware of all the benefits available to the workforce. But there comes a point in time where you do not have to keep someone employed who refuses to comply with the requirements of coming back to work once they've exhausted all of their benefits and rights.
So Sarah, does the child care reg still for employers under 500 employees, and this particular person's firm is over 600 and they have a few staff that can't come back to work due to lack of child care?
Yeah, that does, excuse me, I had a coughing fit, only
Sarah,
applied.
Sarah, you realize everybody's accusing you now of having COVID.
I know, but I'm very socially distant, so I'm good. The FFCRA only applies to employers with less than 500. So that particular law would not apply to that employer.
Great. Well, I apologize, guys. So we're at time. There's been some great questions. So I want to give our panelists one last chance to do a shout out or anything they have to say to wrap up. So Smitty, starting with you, anything in closing?
This has been fun, and I always enjoy learning from Sarah and Suzanne. Thank you all. Let's get back to work. Let's stay safe, and I look forward to seeing everyone in person as soon as we can.
Suzanne?
Yeah, absolutely. I think my message is to really balance the humanity aspect with the business aspect, and, you know, proactively take care of your people as you bring them back, and make it an opportunity for collaborative discussion and figure it out together.
Yeah. Sarah?
I would just say that this entire situation is evolving and shifting day by day, week by week. So be prepared to be flexible and be ready to change if the guidance and the situation calls for it.
Absolutely agree with that. And so in closing, again, I appreciate everybody's time. I know an hour is very valuable. So thank you for joining us. And all of you, we'll have our information, and we'll be resending out to those. If you want to follow up with any questions, we'll be glad to chat with anyone. So again, thank you, everyone. Sorry we didn't quite get to every question.
Thank you.
Have a wonderful afternoon. Thank you.